Look, I really do appreciate you all taking time out of your busy schedule to join me this afternoon for this webinar on family law implications for schools. So my name's Susan Miranda. I'm an associate at Michael Lynch Family Lawyers. I've been practicing in family law since 2000, and a little bit about Michael Lynch Family Lawyers. We've been established for 24 years, and we have 11 lawyers with over 100 years experience. Thanks. We offer fixed cost initial consultations for new clients as well. We see private clients, and obviously it's confidential, and we provide professional advice. So the aim today is to provide you with a general understanding of the practical aspects of family law that you might be exposed to at your school with parents of students at your school. So let's start with some statistics. So of the people going through divorce, 47% of those divorces involve children under 18 years of age. The Australian Institute of Family Studies tells us that the divorce rate is higher for those couples in the age group 25 to 29 years, and that after the age of 55, couples become increasingly less likely to make an application for divorce. So next up, here's an overview of the topics I want to cover in today's today's webinar. Trying to get through nine topics. So I'm hoping that this will take us around 50 minutes, and at the end I'll have time to answer some questions. So feel free to type questions as I'm going along if you think of anything you'd like to know a little bit more about, and I'll get to them at the end of the webinar. So let's get started. The main legislation guiding family law matters is the Family Law Act of 1975. It is Commonwealth legislation. So what that means is that the states, except for Western Australia, have referred their powers in relation to family law matters to the Commonwealth. The Family Law Act deals with all parenting matters and all property matters and any offshoots of those areas. It's activated by a separation of the parties. There have been lots of changes to the Family Law Act over the years, and I'm going to go through some of the more important changes with you shortly. So there are two courts that I regularly appear in. It's the Family Court and the Federal Circuit Court, which was formerly the Federal Magistrates Court. The family court deals with more complicated matters, both more complicated property matters and parenting matters. Parenting issues that the family court might look after are things such as international relocation. So when one parent wants to move permanently overseas with a child, obviously that's an extremely important decision for a court to consider, and there's usually no middle ground whereby the parents can agree on what's to happen. So those matters usually always end up at trial. The family court also deals with matters involving allegations of child sexual abuse, and they have a specific list set up to deal with those matters called the Magellan List. The Federal Circuit Court was created in 1999, and it was created to deal with shorter, less complex matters. It offers a more streamlined process, and it operates more informally than the family court. It was really set up to try to ease the burden on the family court judges. As of very recently, the Federal Circuit Court is offering a more streamlined process for property matters with two new court lists. One is known as the Discrete Property List, and the other is the priority property pools under 500,000 list. Now, I might mention here also another new list that the court has just started to deal with urgent COVID-19 issues. So as a school, I'm sure you're also noticing that there are a lot of underlying issues in relation to COVID-19, especially in relation to perhaps compliance with parenting orders and parenting plans because of COVID-19 concerns. This really raises a question of court orders and isn't really a question that schools should become too involved in. It's a safety issue for parents to make a determination about. And now that the court has this new list, the aim is to try to get matters dealt with as quickly as possible, perhaps even within 72 hours of a registrar having a look at the issue and referring it to a judge. Two types of relationships that we're looking at here, and that's obviously people that are married and also de facto relationships, including same-sex couples. So let's get on to topic number 2, the legal terms and processes. I just want to, I won't go through each of these in detail. Some of them I'm going to address later on in the presentation, but I think it's important that you get an underlying understanding of some of these, the legal terms and jargon. And it's important that it's going to be, the next few slides are probably going to be a bit tough going because I'm referring to legislation, but I think it's important to understand that before we get on to some more interesting topics and about how this more specifically relates to schools. So divorce is really the legal cutting of ties between married couples. In Australia, divorce is a no-fault based process. You can apply for a divorce if you're married, and as long as you've been separated for 12 months and you believe that your marriage has broken down irretrievably. In relation to de facto couples, de facto relationships are defined in the legislation. It's a genuine domestic relationship with trust, intimacy, and personal commitment, and where one of the following gateway pathways exist. So have parties been living together or in a de facto relationship for at least 2 years? This includes same-sex couples. Or is there a child of the relationship? So they may not have been together 2 years, but they already have a child together. Or have parties intermingled their finances? So even though they haven't been living together, they may, for example, have purchased a property together. In those circumstances, it would be unjust not to recognise a de facto spouse's contribution. Importantly, the limitation date in de facto matters for a party to apply for a de facto property claim in court is 2 years from the date of separation. So that's a really important date to remember, because if you separated and you've been negotiating and perhaps that 2-year time limit is about to run out but no property settlement order has been decided upon, one party should really be considering making an application to court before it runs out. If you don't, the court can then decide whether they give the party leaves to proceed out of time, and the courts don't always do that. Also worth noting that for married couples who have applied for a divorce, if the divorce is granted, the limitation period is 12 months from the date of divorce. Now, parental responsibility I'm going to talk about a little later in this webinar. As to mediation, relocation I've already touched on. So interim hearings, I will talk briefly about what an interim hearing is. If you have made an application to court for parenting or property matters, the court can list the matter for an interim hearing, which is like a mini hearing on the papers. That means they're going to be reading the evidence that's been filed and hearing submissions from the bar table, from the legal representatives or the parties themselves that they're self-represented. The court will then make some interim orders which are just designed to tide the people over until the court has the opportunity to test the evidence at a final hearing. Interim hearings usually occur quite early in the court process, and they're usually limited to a 2-hour period. Affidavits, they're sworn evidence filed in court proceedings. It can be evidence of the parties themselves or of a witness. Important to note that if a student unwittingly gets hold of an affidavit that's been filed in perhaps their parents' proceedings, which hopefully that never happens, or if the parent themselves turns up to school and asks you as a teacher, could you just have a look at this affidavit and let me know what you think? If that affidavit has already been filed in proceedings, beware of looking at it, because really that is confidential to the proceedings. It's confidential to the parties and the court process. There are actually penalties that apply in the Family Law Act against publicising their family law proceedings. It's the anti-publication section of the Act, section 121. And like I said, there are penalties that can apply. Subpoenas I'm going to talk about also in more detail a little bit later on. So let's have a look at the possible legal issues facing parents of your school children. So it may just be a simple a divorce. It may be some parenting dispute. There might be some issues about child support payments. Sometimes that can, who pays for school fees, that type of thing. Property settlement dispute. Spousal maintenance. Spousal maintenance briefly is just where one person has been relying on the other person's income to meet their reasonable day-to-day living expenses during the relationship, and they may need that to continue for a period of time after the end of the relationship. Domestic violence I'm going to spend some time on later on as well in this webinar. Paternity, you can apply to the Family Court or Federal Circuit Court to seek an order for paternity testing if the paternity of a child is an issue. And perhaps there might be an issue about a child's name. Now let's have a look at mediation, or FDR, which is Family Dispute Resolution. This is an alternative dispute resolution process. So what is it, and do parents have to do it? So mediation is a voluntary process, and parties are responsible for making their own decisions in the mediation process with the assistance of an independent third party, which is the mediator. So really, it's putting the decision-making process back into the hands of the parents. They know their family the best, rather than putting it in the hands of a judge who doesn't really know their children, their family's circumstances. A mediator's role is to be impartial and to facilitate negotiations between the parties. A mediator is not going to adjudicate. It's not going to tell parents what they should or shouldn't agree on. They're there just to really facilitate discussions. There are different types of mediations. I've listed a few here on this slide. The one most commonly used in family law matters is the shuttle mediation. It's less confrontational. It also works even if there's domestic violence, because the parents are in separate rooms. And that way they're not really sitting across from their ex-spouse. In the shuttle mediations, the mediator will float between the two rooms conveying offers. Whether you have a legal representative with you or not in a mediation is up to the individual. Obviously, if the mediation, there's going to be some serious negotiations, it might be beneficial to have legal advice on the spot about each of the offers made and what counter offers to make. If a person's going to a mediation, they should be prepared for parenting matters. They should be having a good think about the logistics of, you know, how far the school is from their house, how far their house is from the other parent's house, whether the child has any extracurricular or after-school activities, that type of thing. If it's a property settlement mediation, then parties really need to have exchanged financial disclosure so that they know the other person's financial situation and any valuations of issues of assets in dispute should have taken place before the mediation. A Section 60I certificate is important in parenting cases, and that's a certificate that can be obtained from attending family dispute resolution. A Section 60I certificate is really necessary for a person who wants to make an application for a parenting order. It's a prerequisite or precondition to filing an application for a parenting order. The courts are so busy at the moment, they really want to know that parties have tried to work out their issues first by attending family dispute resolution before going to court. So Section 60I certificates, you can get them from registered family dispute resolution practitioners. Beware, not all counsellors are family dispute resolution practitioners. And there are also family dispute resolution centres across Australia operated by different contracted organisations. So people can register for intake sessions with those centres. Beware, there are some waiting lists with some of those centres. There's also an exception to filing a Section 60I certificate in parenting matters if the matter is particularly urgent or there's severe domestic violence, for example. That is a reason why you could proceed without filing a Section 60I certificate. Otherwise, note, if you do try to file an application for parenting orders without the certificate, if the matter becomes before a judge, they may decide that you need to go back and do that Section 60I mediation, that FDR first, and they may even tell parties to try again, file again later after you've done that. Topic 3, parenting matters. So I'm going to talk a little bit more in detail here about the Family Law Act and some changes that have been made over the years, 2006 changes and then further changes in 2012. Here are some concepts on this next slide about parenting matters and concepts that are often spoken about in parenting matters. Pre-1996, there was the concept of guardianship of a child, and you may still hear people refer to that. That concept is now what is known as parental responsibility, and I'll talk a little bit more about that in detail shortly. Pre-1996, that was also the terms custody and access in relation to parenting matters. After 1996, those terms became residence and contact, but now the current position, that's from the 1st of July 2006, is a lives with order and a spends time with order. Now, the best way to convey these changes to you over the years is to give you an example of the type of order that would have been made or may have been made by a court prior to 2006. For example, for a child to spend alternate weekend contact with the non-resident parent or the contact parent. Now, from 2006, the courts really have to now consider substantial and significant time for a child with the parent with whom they don't live with. And therefore, the type of order that might be made now might be something like that a child spends 4 or 5 nights a fortnight with the parent with whom they do not normally live. Now, this is a very broad brush example. Every matter is different and turns on its own facts. And for example, the courts may decide to make an equal shared care order in a matter. So in 2012, the government had an agenda to improve the family law system's response to family violence, putting a child's safety to the forefront in family law parenting matters, without compromising a child's right to a meaningful relationship with both parents. So the principles that the court to consider in parenting matter is a child's best interests being the paramount consideration. Usually both parents should have a high level of meaningful involvement. Obviously, if there's not those other issues such as child abuse, family violence, etc., parents should try to agree on what happens with their children, which is why the courts introduced the need for the Section 60I certificate. So the two main areas in parenting matters, the areas of dispute that we come across regularly, are what parental responsibility should be allocated in parenting matters and what should be the living arrangements of the child. So let's look at the first of those concepts, parental responsibility. There are different types of parental responsibility. It might be parental responsibility about day-to-day issues. So whoever the child is with at the time has parental responsibility for those short-term day-to-day issues, those more immediate concerns. Are the children fed? Do they have clothes? Are they turning up to school on time? Those types of things. Now, in relation to the second of these, the major long-term issues, perhaps the easiest way to describe these is to list through examples of what are considered long-term issues. The first is education, which school a child attends, religious and cultural upbringing of the child, the health issues of the child. Do they need specific health assistance? Is there any major surgery a child might need? A child's name, and changes to a child's living arrangements that make it significantly more difficult for a child to spend time with one of their parents. Now the next of this, equal shared parental responsibility. This is a presumption that's applied under the Family Law Act. It aims to ensure that parents share the key decisions in a child's life, regardless of how much time the child spends with each parent. Parents need to be able to communicate and consult with each other when making decisions about the child's life. In 2006, there were significant changes to the Family Law Act, and that was made via the Family Law Amendment Shared Responsibility Act of 2006. One of the main principles was that children have the right to know and be cared for by both of their parents. Those amendments introduced a presumption in favour of equal shared parental responsibility, but also a greater need to protect children from being exposed to family violence. An effort was made to place greater emphasis on the need for both parents to be involved in their children's lives after separation. How the court considers what's in the children's best interest is set out in Section 60cc of the Family Law Act. It's a legislative path that judges follow when making decisions about parenting matters. And a court must also consider whether a child spending equal time with each of the parents is reasonably practicable, and if it is, consider making an order for equal time. There were further changes to the Family Law Act in June 2012, which provided better protection in family law cases where there was family violence and abuse. So the main change being an update to the definition of family violence and child abuse. Previously, there was a requirement that a person reasonably fear for their safety in order to rebut the presumption of shared parental responsibility. But the new definition provides that family violence is violent, threatening, or other behaviour by a person that coerces or controls a family member or causes the family member to become fearful. So if we look now to section 60cc, the best interests of a child, this is, like I said, this section sets out the legislative pathway a judge needs to follow when making parenting orders and determining what is in a child's best interests. It's like the yellow brick road from Wizard of Oz. So there are firstly primary considerations for the judge. Number A, the benefit to a child of having a meaningful relationship with both parents. And B, the need to protect the child from physical or psychological harm and from being exposed to abuse, neglect, or family violence. So there then are some additional considerations the court must look to. Are there any wishes being expressed by the child or children? So any views taking into account, though, the child's level of maturity. Practical difficulties as well, and the expense of a child spending time with and communicating with the parent, and looking to a parent's capacity to provide the needs of the child, including emotional and intellectual needs. There may also be some cultural considerations, and whether there has been or is a current family violence order and the circumstances around that order. Going back to a child's wishes, I often hear judges refer to this particular consideration where a parent says, but my child doesn't want to go and spend time with the other parent. A judge will often reply, but if your child could elect to go to a dentist, would they elect to go or not? Of course, it's usually no, but as a parent, you know that they must do that and you make them go. Usually it's the same. If there's been an order made for a child to spend time with the other parent, the parent is under a positive obligation to encourage that child to go and spend time with the other parent. This leads me on to the next slide, parenting agreements. So we're up to topic number 4. We're about halfway. We're all doing very well. Well done. Parenting agreements can deal with a variety of issues. For example, who a child is to live and spend time with, or is it to be a shared care arrangement? Who has parental responsibility for a child, and who a child will go to, who will decide where a child will go to school, or who will make that decision, and whether the child can travel overseas with a parent, who keeps the passports, for example, what happens on special days, Christmas Day, birthdays, that type of thing. Now, a lot of parents, when they separate, may just have an informal agreement in place. And that type of informal or verbal agreement works for a lot of parties and they don't need anything else. But sometimes that doesn't work, and then maybe they should look to, the parents should look to having a parenting plan in place. A parenting plan is must be in writing and signed and dated by parents, made free from duress. It's not legally binding or enforceable, but if there's been a parenting plan and it's later breached by one of the parties, causing someone to make an application to court, the judge can have regard to their parenting plan, but they're not bound by it. It shows the intention of the parents at the time of signing it. So really it's where the care arrangements are put into writing based on the agreement, both parents sign and date it. It's also flexible, which works really well with younger children. There's minimal cost to the parties, and it's not binding. Let's have a little look at consent orders now. Noting that a consent order that's been made by a judge has the same enforceability as an order made in court by a judge after a hearing. A consent order can be made without the parties themselves having to go to court. It's where the parties have agreed on something and it's then formally documented, and that documentation is an application form and the terms of the agreement itself. It's in writing, it's signed and dated by both parties. That document's submitted to the court for approval. It is legally binding once it's sealed with the court seal. Parents can negotiate a consent order by themselves or with the help of a solicitor. And once it's been made, though, it can only be changed by further order of the court or by consent between the parties, and it's in place until a child turns 18 years of age. Sorry, I've already addressed consent orders, so we'll just skip over to the next slide now on domestic violence. The legislation in Queensland is the Domestic Family Violence Protection Act of 2012, which was updated in 2017. If we look at the definition of domestic violence, it's behaviour by a person towards another with whom the first is in a relevant relationship, that is physically or sexually abusive, emotionally or psychologically abusive, economically abusive, threatening or coercive, or controls or dominates the second person to cause them fear for their safety or well-being or that of somebody else. Some examples of family violence are listed on this next slide. Causing injury or threatening to do so, coercing a person to engage in sexual activity or attempting to do so, depriving a person of their liberty or threatening to do so, threatening to commit suicide or self-harm so as to frighten the other person, unauthorised surveillance of a person, unlawful stalking, coercing a person to sign for finance, preventing a person from obtaining employment, following a person, coercing a person to obtain social security benefits, or repeatedly texting or emailing another person even. So in May 2017, there were some more changes. The previously protection orders, whether they final protection orders were for a period of 2 years, but from May 2017, orders are now for a period of 5 years. A standard condition that must be included in all orders is that the respondent be of good behaviour and not commit domestic violence against the aggrieved. The magistrate must also consider any additional domestic violence conditions, for example, not to approach a child's school. Also, it's worth noting here that a child can be a protected person or a named person on a protection order. Now, the courts must hear cross applications together now. So if one person files an application for a protection order, then the other person files another application, then they're heard together. It's worth noting that the police can make an application on behalf of the aggrieved person, especially if they're called out to a disturbance, they may do that. Alternatively, the aggrieved person can make an application themselves. The magistrate must also consider any existing family law orders and whether they need to be varied or suspended if they're inconsistent with the need to protect the victim of domestic violence. The magistrate's also required to consider an ouster condition now in all protection order applications. So an ouster condition is where the respondent is removed from the home of the aggrieved for a period of time. Police, if they're called to a disturbance, can also issue on-the-spot police protection notices if they need to, including keeping a respondent out of the home for 24 hours. Some practical issues for schools surrounding domestic violence. Beware that note that there may be a domestic violence order that might contain an order that a respondent not approach within 100 metres of a child's school. If that was to happen, then hopefully the school could, and they became aware of it, the school could call the other parent immediately and let them know that that had happened. Also, a parenting order found in a consent order overrides any inconsistent clause in a domestic violence order. So what that means is if a school's given two orders, one's a protection order and one's a parenting order. If the parenting order is made after, in time, the domestic violence order, then that parenting order overrides any inconsistent clause in the domestic violence order. There are a number of assistance lines that people can turn to if they're experiencing domestic violence. There's the DV Connect Women's line, DV Connect Men's line, a sexual assault helpline, the elder abuse helpline, women's legal service, and community legal centres. If anybody needs a list of those and the phone numbers, please let me know and we can email those to you. Okay, so let's look at some specific issues for schools. What information should your school be provided with when there's a family law dispute? How does your school deal with parenting arrangements? What if a parent wants to change a child's school? And examples of terms contained in court orders that might be relevant to your school. And lastly, I'll cover what orders to watch out for. Okay, information schools should be provided with by separated parents. A parent should make a child's class teacher aware of a separation. It goes without saying, hopefully, that then the teacher can obviously keep a closer eye on that child, and they may be able to recommend a child see a school counsellor if needed. A separated parent should not change or remove the other parent's details as an emergency contact held by the school just because of the separation. They really needs to ensure that both parents remain an emergency contact. There might be some exceptions to this. For example, if there was a protection order like I spoke about earlier, that might mean that a parent should be removed. But otherwise, they really should remain as an emergency contact. And I've seen many parents come unstuck by this in court proceedings where one person has perhaps vindictively removed the other parent or not even ever listed them as emergency contact. It's often a question put to a parent in a trial where there's some cross-examination of the parent, and it can really backfire on them. Also, if separated parents have a consent order or a court order that is sealed by the court, so that means there's a red seal, court seal that appears on the document, then a copy of that should be provided to the school. And often those consent orders provide for the order to be given to the school, and sometimes they also provide an authority of themselves for either parent to talk to the school and find out more information about their child. So how does your school deal with problems encountered in parenting arrangements? A school should be careful about their involvement in parenting disagreements over a child's live with or spend time with arrangements. If a parent's involved in court proceedings about a child, they may decide to issue a subpoena to the school to obtain records for court proceedings, and I'll talk about subpoenas in a little more detail shortly. Sometimes a teacher may be asked by a separated parent to write a letter or report about a child for court proceedings. Seems reasonable enough, right? No, be careful, especially if you are asked to put evidence into an affidavit of any type. As a teacher, if this happens, then you become a witness in the case. You can be asked at a trial to come to court and be cross-examined. So it's quite serious, and careful consideration needs to be given to what type of information the teacher's being asked to provide. And is it independent information, or is the teacher really just putting into a letter something that one parent has told them? If there's one thing I've learned, and I'm sure you teachers are the same, that there's two sides to every story, so be careful about this. The best way for a parent or a party in a matter to get information before the court about the child's school is through subpoena, and I'll talk about that shortly. So what happens if a parent arrives at school to collect their child and the other parent has already taken the child without the first parent's consent or permission, and there's no court order? So what can a school do? Well, firstly, if the school can really only work to a court order and should be really cautious about any involvement in a parenting dispute. If the parent's concerned about what's happened, then perhaps they should be seeking legal advice about what they can do. The parent should try to also speak with their child. Maybe the child has a phone, they can call them and see what's happened. And if the parent's unable to speak to the child or contact the other parent, then they can ask their local police at their local police station to do a welfare check. Or if they're very concerned, they could call the Department of Child Safety as well. A school should not be put in a position of enforcing parenting arrangements. And like I said, if a parent needs assistance and they're worried about what's happened, then they can obtain legal advice about their options. And these options will depend on how their agreement, if they have one, has been documented, if at all. It's usually not a good idea for a parent to keep a child away from school just so the other parent doesn't try to take them from school. That goes without saying. But perhaps a parent could contact the school, give them a heads up that they're worried that the other parent may come to the school and take the child without their knowledge or consent, and ask that the school contact them immediately if that should happen. And I really don't see any problems with the schools doing that. Well, what happens though if a parent wants to change a child's school? So what school a child attends is often a point of disagreement between parents after separation, and it can quickly escalate into a dispute. But for the school's information, it's important to note that parents shouldn't change a child's school unless A, both parents agree, or B, that parent has a specific court order giving them power to make that decision, or power to nominate the school the child is to be enrolled in. And also note that if a person, and this often happens in sort of November, December of each year, there are lots of inquiries about what happens next year. We haven't agreed on what school the child should go to. Even filing an application that late in the year doesn't necessarily mean you'll get heard by the court before the new school year. So often there's still quite a delay in getting on before court, and it can be many months into the new school year before a court can make a decision about a child's school. And remember, the court will be deciding the application based on the best interests of the child, not the best interests of the parent. Now, in the next few slides, I've listed some examples of orders that might be found in a consent order, a sealed consent order, or a sealed court order. So that's an order made by a judge in the Federal Circuit Court or Family Court. Because if you're a school principal or teacher and you've been handed one of these sealed court orders or a parenting plan, you might want to know what to look out for, because they can often be quite long. They might have property settlement matters in there, so you want to flick to the part about parenting and scan for these types of orders. So the first one's equal shared parental responsibility order, which I talked about what equal shared parental responsibility was earlier. And there might be an order that both parents have equal shared parental responsibility about a child's education or future education. There might be an order that in the event the child's school recommends a child participate in counselling, each party do all things necessary and sign any required documentation to give effect to that. Subject to any direction of the principal of the child's school to the contrary, either parent may attend and speak to and spend time with the child at the school during the week the child is living with the other parent. This leads me to some other questions parents might ask the school. They might be asking you, well, we have an order. Tuesday is not the day the child spends time with me, but Tuesday is the day of my tuck shop roster. Can I come to school and do that tuck shop roster? Look, I really don't see any problems with parents attending on days to participate in school activities. The kids are going to love that their parents there, but there are some specific matters where that might not be suitable. If there's some particular emotional concerns for a child, it might be more emotionally upsetting for a parent to attend on a day they know they're not supposed to be seeing that parent. So I guess I would hope that the parents themselves would make some sensible decisions about whether they can attend schools on a day that's not their day. You know, and there are a lot of activities at schools, school reading programs, that type of thing. But most orders would provide for both parents to be able to attend for school events such as school concerts, awards ceremonies, things like that. Some more examples of orders. Either parent be at liberty, this is the one I was just talking about, to attend any event, function or meeting at which parents of a child would normally be entitled to be present. That each parent keep the other informed of a child's progress at school, but more regularly we see the next type of order, that each parent have authority to contact a child's school and request copies of school notices, information, newsletters. It's becoming a lot easier to facilitate these types of orders now that most school newsletters are by email anyway. Changeovers at school. Changeovers at school really work quite well, because what happens is one parent drops a child to school at the beginning of the day, the other parent collects at the end of the day. It involves a lot of stress at changeovers for the parents having to see each other if they don't get along, and for the child itself. So school changeovers really occur regularly. I see it happen a lot in parenting orders. Only problem might be that the child has a backpack full of a change of clothes or something along those lines, or school uniforms get forgotten at either party's house. And hopefully schools can be aware that these things happen and try not to come down too hard on the child for not having the correct socks on. Another type of order, both parties to all such things and sign all such documents to enrol a child at a specific state school or private school. Might just flick over to the next slide. These are issues for schools to be aware of. If you've given a court order which has one of these orders, warning bells should be ringing, highlight it, make everybody aware. Now, I'm not sure if it's come up properly on your slide, but it should be correct. So the first one, that a child, Joe Bloggs, spend no time with the mother or father, whether it's the mother, it might be no time with the mother, or it might be no time with the applicant, and the applicant will be noted who that is. There might be also that specific person, whether it's the father or mother, only spends supervised time with the child. Therefore, they shouldn't be just showing up at school if their time should be supervised only. So we're getting near the end now. Few more things. I might hurry along. Subpoenas. Subpoenas, super important, and I think really helpful for a judge to have subpoenaed information. Subpoenas, if a school's given a subpoena, which will be via the Department of Education if you're a public school, If it's a private school, it might come directly to the school, and it's usually a subpoena to produce documents on a certain date. The school is paid conduct money. That's the Department of Education requires $58. And there can be penalties if you don't comply with the subpoena. The subpoena documents are not sent to the party who have issued the subpoena. The subpoena documents are sent to the court. The court subpoena section hold those documents, and then if a party wants to look at those documents, they have to first seek leave of the court to do that. Once leave's granted, the person or their legal representative can go to the court precinct and look at the documents in the subpoena section. And can I say that I've seen cases won or lost on subpoena documents from a school, especially where a school's kept really good records, for example, about a child's attendance at school. You know, are they attending regularly? If not, why not? If one person's alleging that the other parent's not coping or not facilitating a child attending regularly at school, that can be a huge issue. And whether a child's attending a school counsellor, that it's all extremely important, and it's important because it's independent evidence for the judge. However, beware, I might just flick over to the next one to go through this with you. This is an example of what a subpoena looks like. As a teacher or principal, you might be specifically subpoenaed to attend court to give evidence. If you have a look at the three little boxes in the middle, it'll tell you what the subpoena's for. Is it to give evidence? Is it just to produce documents, or is it both? So, and if you've got to produce documents, up in the top right-hand corner, it'll say documents must be produced to the registry by, and there'll be a date put on that subpoena by the court. So flicking over, this is usually the type of information that we put in a subpoena when we subpoena a school. So it can be, it's very broad. It's really everything a school holds about a child. Next, what is an ICL? ICL stands for Independent Children's Lawyer. They're appointed by a court in parenting matters, in more difficult or complicated parenting matters. They're solicitors practicing in family law who've been approved to practice as an ICL. Now, they're working to ensure that independent evidence about a matter is getting before a court, and that any views expressed by a child are reported to the court in an admissible form, which is a family report. An ICL must act in the best interests of a child, but not necessarily act on the wishes of a child, because sometimes it's not consistent with their best interest. The ICL won't always speak directly to a child. They may choose to do so via, instead, arrange a report where a child can speak to a family report writer who's a social worker or counsellor about any concerns they might have. But an independent children's lawyer may interact with your school, and they do that by issuing an authority to the parents. I can just look over these. They issue an authority to the parents to sign, which gives them authority to approach the school to obtain some information about a specific child, and that's what an authority might look like. And if you get one of those authorities, then that's a valid document, and the school should feel comfortable about providing information to the independent children's lawyer. We're nearly done. The last one, number 9, family reports. I will just touch on this briefly. Family reports can happen before a matter ends up in court, but usually it's a report process that occurs after a matter's already in the court process. It can be ordered by the court, or the parties can agree to obtain a report from a private family report writer themselves. They're designed to assist a judge to make a decision about a child. The family report will provide information about the views of a child and the factors that underpin those views, as well as their relationship with their caregivers and the capacity or insight that the caregivers have about the children. Now, family reports are confidential. This harks back to what I was saying about affidavits. If you're given a family report to read by a parent at your school, please don't read it unless the court specifically orders that you do so, because they are confidential to the process. And again, if a parent provides that report to other people, they're breaching Section 121 of the Family Law Act, which is the anti-publication rule. All right, so we've come to the end of today's webinar. I wanted to let you know that if there were any sort of topics you'd like a bit more information on, or you think might be beneficial to your school staff, please let us know. We're happy to give a more in-depth presentation to your school. If you've got any questions, we'll be sending you a feedback survey. Happy to have any feedback about today's webinar. And you know, don't hesitate to get in touch. If you haven't sent through any questions and maybe you think of something tomorrow, please feel free to send an email to law@mlynch.com.au. Just a reminder, we do have fixed fee consultations. If you know anyone who needs to get a bit of an idea about a family law problem they might have, this is a great opportunity, because we spend as long as we need to in that consultation to answer questions, and that might be an hour to 2 hours, and it's going to be $385 including GST for solicitors or associates, or $440 including GST for accredited specialists. Thank you so much for everyone again for taking time out of your busy schedules. I don't know if I mentioned earlier, I have a very good friend who's a deputy principal, been teaching for 20+ years, and he said that the teachers at his school have been working harder than ever before in the last sort of 3 to 4 weeks to get on top of this remote learning that's been happening. So look, thank you so much as a parent, really appreciate that, and I hope you've enjoyed today's webinar.